Hello, welcome everybody to another episode of Tax Sale Insiders. I'm your host today, Brian Seidensticker. I'm the CEO of Tax Sale Resources, and the lucky interviewer of a guest that we've had on many times before. But Matt Abee is an attorney at Nelson Mullins, and I guess one of the true gurus in the tax sale space, at least in many of the states that he's active in. But I guess Matt, welcome. Thanks for being on again.
Yeah, glad to be here. Candidly, though, I'd love if these courts could stop having all these cases so that we have to do a new podcast every time some crazy new decision comes out or a new big landmark case is going to be heard at the U.S. Supreme Court. You and I could take a break and focus on, the day-to-day tax lien work at some point.
Yes, that would be yes. It's I think everyone kind of assumed after the Tyler Hempen stuff came through that other than states kind of figuring out the rollout, which is still being figured out at least in Illinois, which is another fun story we won't dive into today. But then lo and behold, Pung versus Isabella County came about, and the Supreme Court decided to take that up as well. And so that's the latest excitement, and what we're gonna kind of get folks up to speed on what has happened so far. So maybe let's start there. We don't have to go as there's another episode if you're listening. There's another episode with Matt and Jonah talking about like really what the case is all about. So we don't have to go through all that again, Matt. But just kind of get us up to speed of what got us to where we're at today.
Sure. Yeah, so let me give you like the 30-second overview of what Mr. Pung has been suing about and how we got up here to the Supreme Court. So Mr. Pung had a house in Michigan. It was a family house. After his dad died, the taxes didn't get paid. Mr. Pung had some lawsuits in state court over whether or not he owed the taxes. And ultimately, the state courts decided that he had to pay the taxes. I think it ended up being somewhere around $2,000 for taxes, all the way back for tax year 2012. And when he didn't pay them, the property was sold at auction for about $76,000. He then portrayed that the winning bidder sold the property for somewhere around $195,000, which was roughly what the tax assessed value of the property was. And so instead of suing just to get back the difference in the tax sale bid and the taxes that he owed, a surplus of around $73,000 to $74,000, he sued in federal court to say that he was also entitled to the difference between the tax sale bid and what the buyer ultimately sold it for, that $195,000. So I think that amount jumps up to about, instead of $74,000, it jumps up to $118,000. So Mr. Pung sues in federal court for a violation of the takings clause under the Fifth Amendment, as well as an excessive fine under the Eighth Amendment. After some briefing and things in the lower court, this percolates all the way up to the United States Supreme Court, who agreed late last year to hear the case. So since you and I chatted last with Jonah, there have been a ton of briefs that have been filed. So Mr. Pung has filed his brief on the merits. Isabella County has responded. And then there have been some 25 different parties, friends of the court, who have filed briefs either urging the court to reverse in favor of Mr. Pung or to affirm the Sixth Circuit, which is the federal circuit that covers Michigan, and affirm and allow Isabella County to win. So another interesting development that we've had in addition to these 25 briefs is that the federal government has filed an amicus brief in the case. You might remember back in Tyler, the federal government filed an amicus brief there as well. And that makes sense because the federal government has taxes that they need paid, and
Right.
they levy and sell property when those taxes don't get paid. So the federal government has a vested interest in how this case comes out, just like Isabella County does, just like the National Tax Lien Association does and its members, which, by the way, I don't know if you've read it yet, but the Bronster firm did a bang-up job on an amicus brief for the National Tax Lien Association. So there were 6 other amicus briefs filed on behalf of Isabella County that joined some of the arguments that the NTLA has made. So that's worth a read. But what is a key takeaway for me is the federal government jumping into the fray and filing a brief. And they've even taken it a step further. They've asked to be heard at oral argument. So oral arguments are going to be held in D.C. at the Supreme Court on February 25th. And usually just the parties argue. It's somewhat rare that a third party, an amicus, gets to argue. There's some deference given to the federal government when it asks to join argument, and they usually get 5 to 10 minutes of the argument when they request it. So it's possible, just like in Tyler, you'll have the petitioner argue, then the United States will argue, and then the respondent will argue. So everybody's kind of gearing up now for the oral arguments that'll be at the end of February, and then everybody will read the tea leaves, try and think what the justices are going to do based on their questioning, and then the justices will issue an opinion by the end of the term, usually by the end of June. I think July 4th holiday, we should know how this decision is going to come out.
Interesting. Okay. Well, yeah, it's definitely a lot riding on it. Lots of questions, Matt. But maybe let's start with the U.S. government, filing their amicus, right, and actually being allowed to argue, right. Can't really say it's on either behalf, right, but at least make an argument from the government's perspective. Can you help fill the audience in, as well as myself, on what they mentioned in their amicus that might be what they're also going to reiterate in their oral argument?
Sure. So the government's position on the Eighth Amendment claim, which is the excessive fines claim, has always been consistent. That taxing is not a penalty, and tax foreclosures are not a penalty. It's a remedial scheme. It is trying to remedy the failure to pay taxes. There's no penalty imposed because the federal government in their foreclosures, they only get the taxes that are owed. They don't take anything else. So there's no punishment that occurs there. And so they are pretty staunch in saying that the Eighth Amendment just doesn't apply to these claims. So that's going to be helpful to Isabella County, and is opposing the arguments that Mr. Pung has made. Although you pointed out correctly that the government's amicus brief is in support of neither party, but still the arguments do clash, at least on the Eighth Amendment claim, with Mr. Pung's argument that the tax sale scheme is somehow a punishment. What I think is most intriguing about the brief is the way the federal government suggests that the justices should handle the takings claim. So the federal government says essentially that there is no taking if it's a fair sale. So if the tax sale is properly advertised, if there are a true public auctions that are taking place, then that does not result in a takings. And here's a quote from the federal government's brief, which I think is very helpful. It says, "The nation's history and traditions, this court's precedent, and consideration of fairness and equity all point in the same direction. Under the takings clause, just compensation is the surplus proceeds from the tax sale as long as the sale is conducted fairly." And so I think that's a pretty reasonable position, right? I don't think anybody inside or outside the tax lien industry would say that if there's some backroom deal where the sale occurs and nobody knows to be there and nobody knows to bid up to fair market value or close thereto, that's not what we're talking about in this situation. That could result in a taking of property without just compensation. So I think the federal government's position is very reasonable and could result in a ruling that still preserves tax sales. Because what we're concerned about, at least from an industry perspective, is if you Supreme Court, say that that fair market value is the measure and that a tax lien foreclosure is not fair market value, well, that's going to have disastrous consequences around the country for local governments trying to fill budget shortfalls caused by people failing to pay their taxes. I mean, it would essentially end the tax lien industry's ability to assist with clearing public blight and also supporting the roads and schools and everything that their bids ultimately pay for. So the federal government's position takes a step back and says, well, let's do a fairness inquiry. Let's actually look at was the tax sale conducted in a reasonable and fair manner, such that the bids approximate market value, and if that's the case, then there's no take-in. So I think that that's something that the justices could latch onto as a way to not just set off a nuclear bomb within the industry.
When I think, I guess lots of questions and places to go from here, but I think one of the things that may not be clear to everyone is if that nuclear bomb option ends up happening, it affects not only the style of foreclosures. It really raises the question of is an auction the right way of establishing a market value? And there's many other industries that use that as a way of a fair sale, mortgage foreclosures, for example, IRS I know has their method of seizing property, and how do they enforce those? Could it affect that? So there's a lot wider reach than just this this case that's arguing a tax sale scenario. The argument itself is over, at least a portion of it is over how the sale was conducted and whether that truly established fair market value. I guess I want to dive a little more into that here, but I'm going to state some of the other facts of the case that I'm aware of. I guess I'm going to call them opinions, Brian's opinions. You can correct me where maybe some of those aren't true facts, but I guess things that I've read and heard. One of those is some of the argument that Pung has is very correct and real, at least in its history. It didn't just come up. It's been going on for many years. Well, prior to Tyler Hennepin, the way Michigan's process was the county foreclosed on the property. They would sell the property, but they would keep that difference themselves. And Tyler Hennepin, which in my view certainly made the right decision, said that's not constitutional. Counties can't make this a profit center. They are due their taxes, but Pung is due the difference between what it sold for, so for roughly $79K, and the taxes that were due, roughly $3K, and so that part of the whole history of Pung was right. He shouldn't have been, the equity that was established there shouldn't have been held back from him. That should have been given to him. Now, what the second argument that you mentioned was, hey, the investor, whoever bought it at that auction, ended up selling it for a lot closer to what the assessed value was, after the auction. Another, I guess, maybe it's a myth. I don't know if this has become a fact. You might know, Matt, but it wasn't that the property or the investor turned around and sold it the next day, My understanding is that it was 18 months and a whole lot of rehab on that property to get it back up to that value. So I guess in my view, that's much more of the county assessed value was way behind in its valuation timing, and if it had actually went and valued the property the day it was sold, it wasn't going to be worth $190. It must have been in very bad disrepair. I don't know the dollars amounts that were spent on the property to get it back up to value, but I think that's a fact that is left out a lot of the briefs from I'll say Pacific Legal that is arguing on behalf of Pung, but it is a very valid fact in the scenario of it wasn't that it was bought for 76 and sold the next day for 190. It was bought for 76 probably because it was worth 76 at the time. Investor put X dollars into it, probably a good chunk, and then eventually sold it for 190. Is that your understanding as well?
Yeah, 100%, and it is. I don't think it's coincidental that fact has kind of escaped some of the briefing on the petitioner side, Because that's not a good fact, not just because of the optics of it, but it makes a legal difference. So there was a lot of discussion at oral argument in the Tyler case about when you actually value the fair market value for the purposes of the takings claim within a tax sale scenario. So case law to date has generally said that you value the property that's being taken at the time of the taking, and that makes sense, right? But how do you determine when it is taken? And when you've got title that may go through a redemption period or may go through some other state law process before it actually goes to the bidder. So a lot of the discussion at oral argument was about that, and when absolute title vests in somebody other than the owner. And that's generally when the property is valued. And so in Michigan's case, when the Pung property was sold, there was a difference in about 18 months from when the tax auction occurred and title vested, and then when that bidder sold the property. And so Pung, I don't believe, has a right to the increased value at the hands of the bidder, who went in there, put in, hired a contractor, maybe did the work himself. I mean, whatever the case might be, his work that increased the value, that's not something that Pung should be entitled to. But the question then becomes, well, what really was the actual value at the time of the auction? And I agree with you, it wasn't anywhere near the $195,000 most likely. But the argument that Mr. Pung makes is we don't really know, because tax lien foreclosures are a distressed sale, they depress prices, and there's no way of knowing what really was the fair market value. At a minimum, the county said it was worth $194,000 at the time of the sale, so let's use that as a good proxy. So I don't think that that's a terribly strong argument, especially because of everything that occurred after title had already vested. But those facts are things that have come out through the merits briefing that has occurred since the Supreme Court asked to hear the case. I think that's an important fact, but I think it's also it's important. It might not have a legal difference, but I think that it's important nonetheless, is the fact that Mr. Pung had a lot of different ways there were a lot of stops on the road before the property was sold at foreclosure, where Mr. Pung could have gotten off the interstate and tried to avoid this problem. But instead, he took the fact that the state courts had told him he owed these $2,000 in taxes and largely determined that he wasn't going to pay them. And I think that that's something that can't get lost on the court, is that this is a case that deals with someone who has intentionally not paid their taxes. Now, don't get me wrong, I'm not saying that the takings claim doesn't apply in that scenario, but it does change the analysis a little bit, because you've got to really look at what type of sale and what's the purpose of the sale. Because this really isn't an arm's length transaction, right? I mean, you and everybody in the industry knows when you're bidding on these properties, you're trying to get as much information as possible about them, not only about the state of their title and things like that, but also about what the condition of the actual house or other building on the property is. And unlike a private sale where you can go in and have attorneys do title searches and cure any delinquency, any title issues and clouds, and unlike a private sale where you can negotiate an inspection and due diligence period, where you can actually go in and see the everything down to the studs of the house and check it out, make sure there are no termites, make sure there are no hidden dangers or a leaky roof that's going to cost you thousands of dollars after you buy it. A tax sale bidder doesn't have that luxury, right? The county doesn't allow bidders to come in and tour the houses and inspect them before the sale. And so the reality is these are different sales. A private sale and an auction, they're different. But if you take the federal government's formulation of the argument, that doesn't necessarily matter for the takings clause analysis, so long as the auction is fair. And I think that that's a reasonable position to take. One other point I wanted to make, and you had mentioned this, about this is somewhat more broad of a case than Tyler, and it has more long-ranging and wide-ranging impacts. Tyler really dealt with just Minnesota's odd forfeiture process for tax sales. So if you zoom out a little bit and you think about tax sales on a continuum, on the one far side you've got Minnesota and their practice, which is absolute title just forfeits to the county or the state, the local government, if you don't pay your taxes. That's a pretty hard pill to swallow because you just completely lose title.
Right.
The whole other end of the spectrum would be like my home state here, South Carolina, which is there is a public auction of the property. Bidders bid up to what they're willing to spend, and then you've got a 1-year redemption period before title transfers via tax deed to the bidder. So you've got two completely different ends of the spectrum there. And then through the middle, there are a couple other styles, such as the interest rate bid down method, where you don't actually bid up to the market value, you bid down the interest that you're willing to take. And then there's some variants out there about the percentage ownership interest and the like. So Tyler just dealt with that first scenario, that forfeiture, whereas Pung is going to deal with all of those types of sales, including the public auction type. And so it really is going to have some wide-ranging impacts. But another way that the impacts are broader than in Tyler is the fact that it can involve and potentially affect mortgage foreclosure sales. It can impact federal government foreclosures. Or any type of lien foreclosure that's done by the county for example, if you've got a dilapidated structure and it's not only an eyesore but it's a danger to the community, if the county goes in and demolishes the property and executes on a demolition lien, Pung could, whatever the ruling is, could impact that scenario as well. So I think you're 100% right that this has a wider impact than the Tyler case, which was somewhat focused. And it's also going to impact the states that have made statutory changes to their process based on the lessons learned through Tyler. So it's going to impact a lot, many more industries and states than Tyler did.
Yeah. Interesting. I don't know if I haven't read all the briefs, honestly, Matt. I don't know if this is a fact that has been questioned or maybe the answer to this, but I think a key question to that assessed value of $194,000 is when was that, right? And I think my understanding would be is it wasn't when the auction occurred. It was some time prior to that. How long prior to that, I don't know, right? But I think everyone, at least in our space, and I think most people would agree, right? If it was assessed, right, 5 years or 3 years before, and it sat vacant for that long, right? Properties don't get better with time if they're sitting vacant, right? They only get worse. And so, what is that value? And maybe that is, the issue that needs to be addressed is there's no real, I don't know how to. You highlighted it, and I'll reiterate it, right? It's there's no access to the property. There's so many assumptions that go into purchasing the properties at those auctions that is so different than a typical transaction that most people are used to, right? And when you don't have the time, one, to do the inspections, you don't have the access to do inspections, right? You're making a lot of assumptions. Assumption is you got to be conservative, right? And you don't know what you're walking into, and quite honestly, you could walk into a total loss scenario, right? So where, let's say that property was burned down in the back or had huge issues on the inside, right? It's not worth 194. It's not even worth 79, right? But if the outside structure and from the street looks like a decent house, right? And that's the hard part of this whole equation is what is the value of that property right now? I don't know of a process nationwide that really allows an establishment of value like a private sale does.
Right. Well, and you don't know also what procedures the various different states and various different local governments are using when they are valuing it. Those could be inflated, deflated. You're probably not going to have a realtor, if you go to sell your house, come in and say, oh yeah, we'll just use the assessed value and that's what we'll list it at. Right? There's a lot more that goes into it. And so that's why Mr. Pung's argument that the assessed value is a good proxy. It isn't quite as strong, and especially when you take out the fact that the 195,000 sales price some 18 months later is largely attributable to the work that was done in that 18 months, and not just the value of the house as it sits.
Right.
So
Right.
there's a lot that needs to be considered there. And that's one of the risks of taking Mr. Pung's argument all the way through the case, is if we then are trying to turn judges into real estate appraisers, that's going to be problematic, right? Because I mean, not only are you talking about, in this particular case, the sale or the taxes were back from 2012, right? So not only do you have parties who are asking a judge to help them value the property, a judge who's not an expert in valuation, of course they can hear expert reports and the like and make a reasoned decision, but they're also trying to recreate conditions that by the time this case gets in front of a judge, gets all the way through the filing and the discovery process and everything, there's been a good bit of time that's passed in the normal run-of-the-mill civil litigation. And so you're asking them to also go back in time and figure out what the value was. And so that's another reason why Mr. Pung's arguments are problematic. But what I think is interesting about the case and about the involvement of the federal government in it now is essentially the federal government asks for the same thing Mr. Pung asks in one respect. The ultimate remedy and the ultimate resolution of the case are very similar. Mr. Pung asks for the judgments to be reversed and everything remanded back to the lower courts to determine how much extra value he's owed, and of course the attorney's fees that he's supposed to get for litigating this thing. But the federal government, in a very similar way, the federal government suggests that remand back to the lower courts would be appropriate for those courts to determine whether or not the sale was fair. Not necessarily to determine the fair market value, but whether or not the sale was conducted fairly. And so in that respect, the government's somewhat asking for a similar remedy as Mr. Pung. And so we might not see the end of this case at the end of June. I mean, by the end of the court's term, we may have a remand of this case back down to the Sixth Circuit for a fairness hearing to determine if the Michigan sale was fair. Then, of course, the other option is the Supreme Court affirms and says, nope, just like the attorney at Pacific Legal said during the oral argument in Tyler, the bid is a good proxy for fair market value, and we agree with that. And so that's also a resolution that's out there lurking in the background that could occur is the court could say, what you bid at a tax sale is the fair market value for the purposes of the takings clause.
Right. Well, I think that kind of affirms the it's a saying, right? I didn't come up with it, but it's like there's no one opinion, right? A Zillow value doesn't establish value. Realtor doesn't establish the value, right? A county assessor doesn't establish the value. The only true value of any property is what somebody's willing to pay for it, right? That is what establishes value in all things, right? And so if you start to get away from that, it gets a little scary, especially with, I've heard, right, solutions with, well, just require an appraisal on the property before it goes to auction. Well, the downside is there's a period of time between that appraisal happens and when that property gets sold, and the very vast majority of these properties are abandoned, and that value is dropping like a rock in that period of time. Very different than mortgage foreclosures, where the majority of them are still occupied. Their values are going to go up and down, but really by market, conditions, not necessarily property conditions if somebody is living there, right? And these are, tax sale scenarios, right? The vast majority of these are abandoned properties that are just, falling in value. Well, not to get too far down any of those rabbit holes, Matt, to kind of wrap up today anyway, what comes next? You mentioned it a little earlier, but what's the timeline and what's next?
Yeah, so Isabella County still has some time, I believe, to file a reply brief if they wanted to. Usually they would, but not always required. And then the oral argument is scheduled for February 25th in Washington, D.C. And from there, we'll see what the justices have to say. Again, they could affirm and say that whatever somebody's willing to bid at the sale, as long as it's an open sale bidding up to market value, that is fair market value for the purposes of the takings clause. The court could also adopt the federal government's position, which is the bid is the fair market value for the takings clause so long as the auction is conducted fairly. Or the nuclear option, at least from the industry's point of view, would be the justices side with Mr. Pung and reverse, and they say that fair market value is the actual value of the property at the time that the taking occurs, not what is bid at the sale because it's a distressed sale. And in either the second or the third option, we likely see the case go back down to the Sixth Circuit in Michigan for the judges there to determine either was the sale fair, or to determine potentially what is the amount of surplus and just compensation that's owed to Mr. Pung, and how much in attorney's fees he's owed.
Got it. Thank you. Well, Matt, I thoroughly appreciate it every time. Sounds like we'll be talking again sometime after February 25th to see how the oral arguments go. So we're certainly not at the end of this saga. It will continue. But thank you again.
Yeah, thanks for having me.
Hopefully everybody learned something today along with myself. And, I guess good luck, everybody.